It's an honour to lead this debate on domestic abuse offences, and a particular honour to do so from the very spot in which I witnessed or saw given the most moving speech that I've ever seen in the House of Commons. It was in 2016, November-December time, and it was given by Michelle Thompson, who was then the independent Member of Parliament for Edinburgh West. And she spoke about her experience of abuse, being a victim of violence at the hands of a man. And at the end of that speech, she said, "I am not a victim, I am a survivor." And those words sent a shiver down my spine, gave me goosebumps, and unlocked in me a real determination to try to use my own experience and my family's experience to try to improve what life is like for victims and survivors across the country. And I say in Michelle Thompson's words that I too am not a victim, but I am a survivor. Yeah. And as a result of that, and also my mum's experience at the hands of a former partner of hers, we know what domestic abuse looks like. I know what it is to be crying upstairs under the covers as a child, listening to shouting, screaming, smashing, and the rest coming from downstairs and not knowing if mum was okay. I know what it is to go downstairs the morning after and see broken glass or a kicked-in Hoover and the rest, and to not know whether mum was okay. I know what it is to live in a household where you're worried that any word that you say, any movement that you do, any thought that you might have can be attacked by an abuser in your own home who's meant to keep you safe and who you are meant to trust. There are so many people across our country who are victims and survivors of domestic abuse and other forms of abuse. And it's estimated that 1 in 5 people will be a victim or a survivor of domestic abuse in their lifetimes. And in my view, the law does not go far enough to protect people in those circumstances. Great progress was made in 2021 by the last Parliament in the form of the Domestic Abuse Act, which defines domestic abuse in the law for the first time. It also created a series of domestic abuse-aligned offences like coercive and controlling behaviour, non-fatal strangulation, non-fatal suffocation. But I'm afraid that that piece of legislation, and indeed our legislative framework overall, does not go far enough to recognise the domestic abuse that my family has experienced and that many members of this House will be familiar with too. And an example of a failing in the law has existed in the form of the experience undergone by an extremely brave and inspirational survivor, Elizabeth Hudson. Yeah, yeah. Elizabeth was a victim, a survivor of domestic abuse at the hands of her ex-husband. He, among many other terrible acts at home, held a knife to her throat. In response, he was convicted of assault occasioning actual bodily harm, ABH, for his crimes. And for her and for so many, such a conviction does not reflect the full gravity, the full circumstances of such a nefarious crime. And that's led to all sorts of problems, not just for Elizabeth, but for many other survivors as well. But there's so many areas in which the law could do better. And I was speaking about the early release scheme as an example. the scheme being one in which folks who were released would serve 40% of their sentence rather than 50% of their sentence. And the government very nobly made a commitment to survivors that it would do everything possible to exclude domestic abusers from being released early under the STS 40 scheme, recognising that it can be super destabilising for survivors who need to prepare for when their abuser is back in society, back in their community, back in their neighbourhood. But unfortunately, we know that there are many domestic abusers who were released early under the STS 40 scheme. And it happened because the only way in which you can exclude someone or include someone within an early release scheme is on the basis of the offence that they've committed. This is something that the Justice Secretary has confirmed, and not on the basis of anything else that we might know about their behaviour. But the problem is there is no specific offence of domestic abuse in the law. We therefore cannot properly exclude those people from such an early release scheme if that's something that we're committing to those survivors. Instead, we know, just a second, I will take his point. Instead, we know that domestic abusers are often convicted of ABH or assault or battery, and these are offences that were criminalised by an act that was written in 1861, the Offences Against the Person Act, which is not written with domestic abuse in mind. As a result, there are so many domestic abusers who are falling through the cracks, Madam Deputy Speaker. And more than a national crisis, this is a national emergency, and Women's Aid have rightfully declared it so. And that's why it's more important now than ever that our legal framework properly recognises domestic abuse in the law. So I've described how our current legislation, in my view, is leaving survivors without the respect and without the protection that they deserve. So many of survivors' abusers, for example, qualifying for early release when they shouldn't be under what the government has intended. Now, I've raised this a number of times in this House and beyond. I've raised it on the Justice Select Committee. And Ross Gribbin, who is a Director General at the Ministry of Justice, confirmed that the only way of correcting this, the only way of closing this loophole is through primary legislation, legislation that this House must debate and must vote on. And so that leads us to think about what kind of solutions are there to patching up what is a legal loophole. The solution must be to create a specific offence of domestic abuse in the law. I've proposed a very specific way of doing that in consultation with a number of stakeholders, and that is to create a series of domestic abuse aggravated offences in the law. So in the same way that we have racially and religiously aggravated ABH, GBH, assault, etc., we would have a domestic abuse aggravated equivalent. And the law is already going some way to help achieve that. So domestic abuse is already an aggravating factor in sentencing at the back end, but is not an aggravating factor at the front end in terms of the offence that people can be convicted of. And we know there's precedent to make something like this happen, to create these domestic abuse aggravations, because the Crime and Disorder Act was an act that introduced racially or that introduced a number of aggravations, and it was extended to include racially and religiously aggravated aggravations. And so we ought to amend that specific piece of legislation to include this in it as well. But this is about far more than just early release schemes, for example, and being able to include or exclude domestic abusers from those schemes. This is also about data. I asked a written parliamentary question to the Ministry of Justice. It was a very simple question just before Christmas, and the question was, how many domestic abusers are currently in prison, and what is their reoffending rate? The response was this: It is not possible to robustly calculate the number of domestic abusers in prison or their reoffending rate. This is because these crimes are recorded under the specific offences for which they are prosecuted. I.e., we don't know how many domestic abusers there are because there is no specific offence of domestic abuse in the law. Instead, they're convicted of offences, for example, under the 1861 Offences Against the Person Act. This is a national scandal. We should know how many domestic abusers there are in prison. And in fact, the government has a really powerful ambition that I fully support to halve violence against women and girls over the next decade. But how can we possibly know if we're achieving that, if we don't know how many domestic abusers are in prison at any given time? And more than that, if we're serious about reducing reoffending, and I've dedicated my career before coming into this place to do exactly that kind of work, how can we know what kind of interventions are most successful when it comes to reducing reoffending if we don't have a way of measuring it because there is no specific offence of domestic abuse in the law?
On that note,
of course.
I commend you for speaking so eloquently and movingly about the Honourable Member's personal experiences. Madam Deputy Speaker, there's a recognised link between animal abuse and domestic abuse, and I pay tribute to organisations such as the Link Group, which train veterinary professionals to recognise when cases they are seeing may be indicators of abuse, domestic abuse. And it ties in exactly to what the Honourable Member is saying, that if there isn't a specific crime of domestic abuse, it is really hard to signpost and give guidance to everyone in the community to be able to know how to proceed forward to ensure that people are identified early and helped at a very early stage.
I completely agree with the Honourable Member for Winchester. We know that there are links between domestic abuse and animal abuse, say. We also know that there are links between domestic abuse and child sexual abuse, for example. This is a link that I have experienced the hard way. But again, our legislation and the data that we're collecting is not helping us in as far a way as it could to help us make that link so that we can figure out which interventions will be best at busting these social ills. There are more reasons why a specific offence of domestic abuse is so critical. Let's take Clare's Law. Clare's Law being the scheme that allows individuals, but mostly women, to request to see information about the offending histories of their partners. They get to see things like the charges that individual has been subjected to, or the offences that they've been convicted of if they qualify for the scheme. It would be very easy for an abusive partner to explain away a conviction or a charge for assault or battery as a brawl between them and a stranger in a pub, say. But can you explain away domestic abuse aggravated assault in the same way? No. Of course.
I'd like to thank my honourable friend, Madam Deputy Speaker, for such a powerful speech and for his courage and leadership on this matter. He asked about the ways in which the perpetrators of domestic abuse might hide their crimes. And I have to say, in my constituency of Bristol and Woodstock, I've heard too many examples of women who are suffering abuse but are not finding a way to cut through to the authorities. Will my honourable friend agree with me that too often cuts to victim support and an inaccessibility of legal aid is preventing those who are the victims of domestic abuse from actually being able to start the process that might ultimately lead to the kinds of aggravated offences that he is so rightly calling for?
He's absolutely right. It's critical at a time like now where we've heard about the scale of the national emergency when it comes to domestic abuse, just how important it is that victim support organisations are adequately funded. And I've met with a number of organisations, take victim support as an example, that in light of cuts to PCC core funding, but also the national insurance contribution increase, that they're facing a 7% real terms cut in their funding. We should be funding these organisations more, not less at this time, to support constituents like the very ones that my honourable friend has mentioned. Now, there might be some challenges to the proposal that I'm putting forward, and a challenge that was put to me is that, Josh, might this not lead to the very sentencing inflation that the government is trying to avoid now to ensure that our prisons don't fill up so quickly? My response to that is twofold. The first thing is that domestic abuse, as we've explored already in this debate, is already an aggravating factor in sentencing. It already carries a greater sentence. What I'm proposing is that we enhance the front end, as I said earlier, not just the back end. The second response I have is that if we look at the crime and policing bill that the government put before this House very recently, and we had our second reading of the bill last week, there are a number of brand new offences that are created in that bill, offences that I completely agree with and commend the government on. Things like assault of a shop worker or a dedicated offence of spiking. These are the right things to do. But if we can do them for those crimes, surely we can do them for the crime of domestic abuse. And I remember in that debate for the crime and policing bill, there are a number of honourable members, but particularly on the government side, who praised the trade unions for their campaigning to get this offence of assault against a shop worker over the line. And I agree that great campaigning by trade unions helped to achieve that. But domestic abusers, or their survivors and their victims, do not have such a union. We in this House are their union, which is why we must campaign for a dedicated offence of domestic abuse to protect them. Now, I'm really pleased, I'm really proud that there are so many who have rallied around this proposal to create a specific set of domestic abuse offences in the law. They include Women's Aid, they include Mankind, they include Refuge, they include Victim Support, and many more charities and support organisations in this space who believe that this needs to be done. I'm really grateful to many of my Liberal Democrat colleagues who are sat around me for backing this proposal, but also those across this House, and particularly thankful to those members on the government benches who have privately reached out to me to express their support for these proposals. And I know a number of them have expressed that support to their front bench as well. And I'm very grateful to lots of our media outlets for getting behind this and for platforming this campaign as well. In particular, the team at Good Morning Britain, who helped me launch this campaign and this very bill that I have in my hand to make this offence closer to reality. And I also thank lots of the very warm and constructive conversations that I've had with ministers, including the Minister for Victims, including the Minister for Safeguarding, who I met with a couple of weeks ago, including the Minister for Prisons, the Lord Timpson, but also the exchanges I've had with the likes of the Solicitor General and the Secretary of State for Justice in this chamber. I really appreciate that constructiveness, but I'm really keen now for even more than warm words. I'm keen for action. Victims and survivors need and deserve the recognition that a creation of a brand new specific offence of domestic abuse in the law would create, and I stand ready to work with literally anyone in this chamber and beyond to make it a reality. Thank you.